Hello, everyone, and welcome to DAO Today panel. I'm your host, Alexa Mill. Today, we'll be discussing how CFTC's chatbot serving threatens DAO governance. First, I would like to welcome our guests, Bian, Michael, and Matthew. It's great to have you here. Would you please introduce yourselves to the listeners and share with us what's your involvement in the industry? Bian, please.
Thank you. I'm happy to be here. So, quick on me, I'm an attorney from Germany. I started in crypto around 2015, and since 2016, I got really involved, or got really hooked on DAOs, and decided to write my PhD on the legal qualification of DAOs. And since 2017, I've been working as a lawyer with a lot of different companies regarding DAO setups, token setups, corporate structure, and I started my own law firm in that regard and have been working with a lot of clients, especially like in DeFi, but also traditional crypto VAS for licensing and stuff like that. And we have to on the podcast here and discuss this interesting case, which I think has a lot of impact all over the industry, right?
Yeah, it's a very important topic, and I know that on LinkedIn you did post several analysis. I'm really looking forward to having you here and discussing this. Thank you. And Michael, would you please tell us a bit about yourself?
Yeah, absolutely. So I'm an attorney at the law firm of Wilkie Farr & Gallagher in New York City. I focus entirely on crypto regulatory and commercial issues. I got into Bitcoin really in 2011, before there was really a full crypto industry, and I kind of fell down the rabbit hole just out of interest. And a few years later, I went on to work for former chair of the Commodity Futures Trading Commission, Christian Carlo. We were first kind of looking at how Bitcoin should be regulated, whether it's a commodity under the Commodity Exchange Act, and if so, whether we could authorize the trading of commodity futures on Bitcoin. Since then, I've been in private practice, and I've worked entirely with crypto asset issuers, exchanges, DeFi protocols, and developers on a wide range of regulatory and commercial issues primarily under the Commodity Futures Trading Commission's regulatory ambit, as well as the Securities and Exchange Commission. But I spend quite a bit of time working on anti-money laundering and sanctions issues as well for clients, and in particular in the DeFi space.
Great, thank you for the introduction. And Matthew, please.
Hey, I'm Matthew Kimber. I was previously a restructuring and insolvency lawyer at a Magic Circle law firm in England, and now I work at the Law Commission of England and Wales, thinking about private law reform in respect of digital assets, crypto assets, and particularly in respect of DAOs. So yeah, that's the kind of the work that I've been doing over the past 18 months, 2 years.
Amazing. Thank you very much. And thank you all for coming today. Before we move into the topic, I would like to remind everyone that this panel is for educational and informational purposes only. Nothing said by myself or my guests can be construed as legal, financial, and or business advice. And mentions of any projects do not represent any sort of endorsement and or promotion. So as I mentioned earlier, today's topic is the Ooki DAO, a very important case that recently got a lot of attention, but unfortunately not enough. A quick overview of the Ooki DAO. It's built on Ethereum, a protocol that for tokenized margin trading and lending. It's a financial primitive for shorting, leverage, borrowing, and lending that empowers decentralized, efficient, and rent-free blockchain, as they introduce themselves. It's actually formerly known as BZX protocol, and that was developed and marketed by a B0X LLC that was formed by Tom Bean and Kyle Kistner. And unfortunately, in 2020, the protocol was hacked several times, and which actually led to the founders' probably decision to transfer the ownership of the admin keys to the BZX DAO, which was later renamed Ooki DAO. And Ben, since you were heavily involved, actually assessing a lot the Ooki case and its effects on the industry, would you please do a quick overview of what actually happened with the Ooki case and what was the CFTS claim to file charges against them?
Yeah, definitely. So I would try to break it down on the most interesting claim that the CFTC made, and basically the claim, which is here from a lot of importance for every DAO, is that they claim that DAOs are under U.S. law, under state law, unincorporated associations with the legal consequence, which they claim that everyone who voted in this DAO is personally liable for the actions. And of course, there was a lot of backlash against that, a lot going against it, because there are arguments, of course, going against this claim. But I would say that's the most obvious and the most interesting claim here. Also, what I said before, I think it's interesting to note that they are seeing this as an unincorporated association of people, of only the participants who voted in that DAO, which I also think has some important consequences in the long run and for other DAOs. And that's where I would break it down to the main problem. But if any of the others also see some interesting case in that regard, I would be happy if they also contribute to it and say their thoughts.
Thank you. Michael, Matthew, is there anything else you would like to add?
Yeah, I mean, I think there's an interesting issue in that DeFi protocols kind of exist in a gray zone. So there's certain types of transactions that have to occur on regulated platforms. So whether it's an SEC regulated national securities exchange or a CFTC regulated designated contract market, and there's the idea of a kind of OTC markets that are regulated these days. So after Dodd-Frank, we have also securities execution facilities, swap execution facilities rather. And so there's a hybrid type platform model as well in the United States. Some of these transactions, the fact that some of these transactions are occurring in DeFi raises some interesting questions. Margin leverage or financing to retail customers really can't happen without a registered broker, a futures commission merchant, and a CFTC regulated DCM. So some of the arguments that the CFTC is making here make a lot of sense. I think the issue that's concerned a lot of the industry is the fact that these DAOs, aren't necessarily legal entities that you would think of that are offering the types of platforms that the CFTC is used to regulating. And so serving notice, for example, to an unincorporated association raises some unique issues.
Thank you. Matthew, is there anything you'd like to add?
No, I broadly agree with that characterization. I think the way that we've been thinking about DAOs is particularly to go on to Michael was just saying, to analyze how DAOs are made up and the constituent elements of those DAOs. So they are protocols, sets of smart contract code, which are themselves open source, and then are then deployed to normally open source blockchain protocols as well. They do facilitate transaction or transaction-like actions being participated in by users of those protocols, but they also rely on a whole load of assumptions to get to that transaction-like quality, including rational actions by miners or validators, rational actions by block builders, assuming that the blocks will be built correctly and then mined and added to and the state change system. And many of those protocols also distribute tokens or kind of emit tokens to a disparate group of holders who may or may not have input or may have different levels of input on how the protocol itself manages certain limited functions. And then separately to those holders of tokens, there will be developers who may work independently or may work for a company or a foundation or something else who work on code. There'll be marketers, there'll be other people who build the front end website, which allows people to kind of interact with the protocol by running scripts and giving back a JSON object so that they can then interact with the protocol. And what we're thinking about is looking at all of those pieces and looking about how the interrelationships between all of those constituent pieces work, because that's quite complex, right? And the way that the Ooki DAO case was brought was just to say, well, let's take all those pieces, all bring them together and call that an unincorporated association. And we're questioning whether or not, it is correct to broadly categorize that as an unincorporated association, as opposed to look through each of the kind of constituent pieces and look at how those interrelationships all work on a kind of an individual / peer-to-peer basis. So that's kind of pretty much what Michael said, I think. But
thank you for that. And tell me, what do you think, what will be the fact that they are seeing Ooki DAO as an incorporated association and the way how they actually served the organization via chatbot and forum message, and they even went to Telegram group asking for someone to volunteer to be served. How that can actually affect the way these things are communicated to DAOs, and the fact that they're going after the people that voted on the project matters that necessarily do not fall under compliance issues, how that can affect DAOs on a larger scale. Dr. Bian, would you share, please?
Yes, so as you said, it was quite interesting, the pledge of the CFTC, when they said they were seeing that there was discussions about the complaint in Telegram channels and on Reddit or on Twitter. And I think it's a little bit of a contradiction that they are then saying, on the one side, they are not saying it's a purported organization, but on the other side, they're saying, okay, we can just, the notice is enough when people are discussing over it. So it's a little bit difficult to really, like from a legal perspective, to really say that the CFTC is doing a fair job here. Because on the one hand also, which is I think really interesting, they already settled with the two founders of the Ooki DAO protocol. And then they're on the second side, they are suing the individuals who are voted on that, and they're just say as a serving there would be enough that they are discussing it, but they don't, because it's announced, they don't know if which they will probably sue as individuals are actually got the notice and serving it. So I think there's a little bit of contradiction on that side, and it's like they're trying to get like two pieces out of one protocol. One, they're settled with the founders, and then on the other side, they're saying, but that's not only the founders who have it, also every individual. And I think, as also Michael and Matthew explained, there are good arguments against it that this is a legal person under U.S. law. Of course, they are deeper into U.S. law than I, but I share that opinion, and I think it's a little bit an act of the CFTC to make a statement in that regard, which I think raises some proper legal questions. And I think if there's a fair judgment on that, it will be hard to hold that case, because how the CFTC is following on this case, I think there's a lot of contradictions.
Yeah, I mean, at least we know they can be innovative when they want to, right? Since they actually went to the website and served via chatbot and the forums. So they did find a way. However, the fact that even that the court decided that type of serving the notice puts many at risk, and on the other side, the DAO governance can be in quite danger. The fact is that not each and every DAO falls under the SEC or CFTC jurisdiction. However, if we tag that those that are voting on the governance matters, that on the project matters, that do not even have nothing to do with the compliance, puts many at risk. And expanding like a forum platform or chatbot, even Telegram group, like probably the next one is in Discord, it just does not really show a good way to communicate, and does not really constitute a legal way to do this, to file charges in this manner. Michael, would you please share, since you're from the U.S., what basis did the court actually allow for this serving to happen via chatbot?
Yeah, I think a couple of important points here. So, a general partnership or an unincorporated association under U.S. Corporate law, it's state by state. But generally speaking, as long as you've got two or more persons that running a business for profit, there's going to be a general partnership or an unincorporated association under U.S. law. There's also separate kind of requirements for serving process and what counts as an unincorporated association or general partnership for purposes of serving process under our federal rules of civil procedure or state rules if you're serving under state court. In this situation, really what happened was you've got a bunch of individuals with governance tokens. You don't have an easy way to identify who those individuals are. You have these original founders who have pushed off responsibility and governance control over the protocol to this, association, this organization. And so, you've got a regulator that says, well, like, we've got rules that we need to enforce. There are certain types of transactions that need to occur on a regulated platform. This group, the group of founders kind of push things into the DAO, and then they have statements saying they're doing this in some respects to evade regulation. And so it puts the regulator in a tough spot, right? The regulator, they do nothing. They're kind of telling the market, go ahead and use this model. It's a great model. You don't have to comply with regulations. And that's certainly not what the U.S. CFTC or SEC is going to do in that situation. And so they need to serve process. They needed to give notice to this unincorporated association. It's not really a complex legal issue as to whether there is an unincorporated association. So the question is how you serve process. There's a typical method that would not work here, right? Because you don't know who the general partners are. It's a bunch of pseudonymous token holders. And so they decided to provide notice through the chat box and through the governance forums, putting posts out there. And then, of course, you have all of the discussion that comes out of that. So a large number of these token holders likely were on notice, unless you're living under a rock somewhere. You know what's going on with the Ooki DAO. There's amicus briefs filed, it's become a large issue. So the CFTC's argument is not that they're trying to seek judgments against all of the token holders, which is an important point. They're trying to seek judgment against the DAO treasury. So the specific, smart contract that holds funds, that's what they're looking to seek a judgment against. They're not saying, token holder A and B, because you voted on these proposals, yes, you're a general partner, but no, we're not seeking a judgment against you. So we're not actually trying to bring a lawsuit against you or seek a claim against you for funds or for anything else. So I think that's an important point to consider here. I mean, this is going to have a chilling effect on governance participation, but the CFTC is being a bit measured in what it's pursuing. It's not going after individual token holders.
And what do you think whether that the fact that the founders went a bit, allegedly went boasting a bit, like, well, now we don't have to do KYC now with the DAO, we don't have to comply, we don't have to follow any of the regulations, and on top of that, a few years back, they did suffer around 50 million in hacks, which actually prompted them to move from the BZK LLC. Whether those were the triggers for actually why CFTC went after Ooki DAO.
Yeah, no question. I mean, I think the fact that the founders kind of transitioned this protocol, governance over the protocol, to a DAO, which is, a trend. I mean, and I think there's various reasons to do so. Usually the reason is more of a decentralization concept and potentially to make arguments that the token itself, the governance token, is a non-security under the securities laws. But the idea here, there's statements by the founders basically saying, look, we don't want to be regulated as a DCM or as an FCM by the CFTC. We're going to push this off into a DAO, and we think that if we put it in a DAO, there's no basis to say that this has to register with the CFTC, and that's just not how the law works. The law says that if you're a person, and the definition of a person includes any association, you're required to register as an FCM if you're offering margin leverage or financing, or as a DCM if you're offering, what's known as a futures exchange, and all of these retail commodity transactions for the purchase or sale of a digital commodity on margin leverage or financing are required to be treated under the law as futures contracts. And so they have to trade on a regulated platform. And so, this is not necessarily the best case for looking at other protocols, because there are only so many protocols that are offering margin leverage or financing or offering derivative products. And those are going to trip up against some of these requirements. And, there's arguments to be made, that they shouldn't fit within the regime, but a lot of these laws are fairly black and white, and I think that's why some DeFi exists in a gray area, some doesn't, and the legislation that we're looking at on the House, in the House and the Senate in the United States, some of that might move the needle, but to date we've not really seen much by way of DeFi legislation. There's been some talks about potentially wrapping these into the DCCPA, but that was very unpopular, and so it's likely died on the hill.
Yeah, the problem is that really casts a bad shadow over DAOs, because the statements such as, well, we are DAO now, we don't have to follow any compliance, we don't have to do any KYC. It sends a bad message, I believe, both ways, both to the regulators and the community and DAOs, because if one did it, why wouldn't the other follow? And the fact is that we live here, and that we have to comply with the laws that exist, like them or not, to the best of our abilities, considering that there is no actual regulatory clarity when it comes to the industry, and it's a lot applying of the laws that were made a lot before blockchain even existed. And Dr. Bien, would you please share with us your opinion on this matter, since you've been heavily involved in DAOs for a very long time, and what is your take? What kind of message does this send to DAOs, to communities, and to regulators?
Yeah, so just touching on what Michael said, as he said, of course, the CFTC is here not targeting individual persons, but I think the statement that they basically could, and the token holders are personally liable for the action of the DAO, is such a big sword hanging over every DAO, and basically confirms the risk that all the lawyers had in these cases. And I think, and we already see, and I already do that with my clients on base rate, it changes a lot in DAO governance. So I think voting or anonymous voting becomes really important more and more, and DAOs try to find a way to have a way where people don't really expose themselves when they vote. And I also think in this case, it's a little bit unfair that the CFTC basically, as I said, goes behind this on two parts, and also creates a precedent for all regulators all over the world to actually qualify DAOs as partnerships. And I think, as there are good arguments that some DAOs could be seen as some kind of general partnerships or joint ventures, but on the other hand, I think there's also a good argument to see DAOs just as a social group gathering together, right, which don't has any legal intention on being bound by corporate law, or they don't have an intention to be legally bound by a corporate law structure which they get into. And on the other hand, what was really beneficial is that the CFTC, in the reply to the Amico statement, said that legal wrappers actually work, and they basically said that DAOs which are wrapped in some kind of legal entity are protected, which also wasn't sure, because if you look at it from a corporate law perspective, all these offshore foundations that have been created all over the Caribbean and everywhere for DAOs, basically the foundations can't really wrap all token holders. They were sitting on top of the protocol as a legal entity, but when the CFTC actually approved that, or said that they had some kind of protection, that also had the consequence that a lot of DAOs went towards that direction and are now setting up legal entities. And on the other side, I think the only solution for DAOs who don't want that point of centralization with the legal entity is to go really, really decentralized. And I think a lot of projects think they are decentralized, but they are not decentralized enough to basically don't fall under that regulation. And what I have done, and what I think is one kind of solution, is to have on-chain participation agreements where we really stress the point that this is not creating any kind of general partnership. Of course, this is just a second layer of protection, which doesn't create any any legal certainty or legal protection. But I think with this, like on-chain agreements and further decentralization, you can just help to make it really hard for potential plaintiffs to claim that this is some kind of legal person or general partnership. And I think we will see a shift towards these two extreme directions, that all the DAOs and protocols will be more cautious regarding their legal setup. Because what we have seen in the last year was just like, we are going for it, and mostly lawyers were engaged when it was already too late or when trouble got already started. And we are seeing now that it's as soon as they are starting, they're involving lawyers to have some kind of like legal structure by design when setting it up. And I think that's a big change, and that's the way to go in a lot of structures in that industry.
Yeah, that's what I've been noticing with DAOs a lot is, well, when it's already late, well, we need to call a lawyer, and by the time it's really difficult to help solve some of the issues, and just the liabilities got so big that you cannot do much. And what I've been hearing a lot while working with DAOs as well is that, in my opinion, a myth that having that entity that represents a DAO is a type of centralization, because what that entity does is actually gives legal protection to the projects. And what centralizes actually the DAO as a DAO is how that governance and how those operations are structured. And if they are structured in a centralized manner, when you don't have the actual decentralization of the project and the decision-making power, well, that's the main problem, not that legal entity sitting somewhere and being some sort of like a shield from any potential legal issues that may arise. And having that on-chain governance, very clear on-chain governance as well, that does outline that and gives that entity a very specific role, and that is to legally protect the project and limit the liabilities of those involved, while the project is still a decentralized environment where the community has the say. And unfortunately, many DAOs, more than they should, they claim, they say that the entity centralization, and do not talk much about the fact how there is governance and operations are actually very much centralized and not structured the way they should. And Matthew, what do you think of this? What impact can this have generally on the industry and the DAOs, and what are some of the options how this could be mitigated in the future?
Yeah, I think the points that Bian and Michael made were really interesting, particularly the one around what, in this case, was the actual kind of liability attracting action or action that actually attracted the liability. And Michael explained it pretty well. I think he was talking about effectively the protocol almost by its very existence offered either the mimicking or the complete ability to take leverage trades without the kind of corresponding regulatory kind of compliance or registration or whatever it was, which Michael explained way better than I can. And that's a really interesting point, I think, to consider, because that is offered or facilitated via open source code, which is deployed to open source blockchain protocols. And participants have to engage in that transaction, they have to interact with that open source code, and they may do it through a website, but they also can, if they're kind of sophisticated enough, they can not do it through a website. And that was actually the kind of the liability attracting action or kind of set of circumstances in this case. It wasn't users suing the protocol or users losing funds. It was actually that kind of non-compliance. We're not really used to seeing that level of non-compliance for non-person things or non-company things which have legal personality. And even if you don't have legal personality, you get there some other way via an unincorporated association which doesn't have legal personality, and you look through to the people who are part of the association, or via a general partnership analysis, you look through to the partners who then don't have unlimited liability. That's a bit different here because the token holders weren't really the guys who built the protocol, right? They didn't really get any fees, I don't think, being run off through the protocol. They don't really have any input on the protocol. They didn't build the website, certainly. They didn't market it. Lots of the token holders, though, were probably kind of part of the pre-mine, part of the kind of ability to sell their tokens as and when that protocol's tokens became more valuable because more people used them in the market and thought that, well, this is a good service provided by the peer-to-peer protocol. But that is slightly different, right, to the normal way in which we think about attributing liability. And you can see why the natural reaction when something bad has happened or some non-compliance or whatever it might be has happened is to just go, oh, well, it's overall a unincorporated association. We just treat this in the normal way. But I think that misses an opportunity to really investigate what is happening and what is different about code that runs deterministically that is deployed to open source blockchain. So I'd be interested in hearing maybe Michael's view on whether that could be explored more, or those points, or maybe Ian as well.
Yeah, I mean, I think the U.S. State by state corporate structure for DAOs is crap, right? Like, we don't have, aside from Wyoming, a regime that really is tailor fit for DAOs, and the Wyoming regime is really just an LLC regime with DAO slapped onto the name. We don't have a structure that says, okay, this is how DAOs work. Everyone has a governance token. This governance token, represents their interests in the organization. Everything happens on chain, or certain off chain occurrences might happen that are voted on using the token, and then kind of tailor fits liability and structures all of that within a corporate model. I mean, the closest thing is really the UNA, the Unincorporated Nonprofit Association, which is kind of the sister to the Unincorporated Association, where there's not a pursuit of profits. And so if you have a group of individuals that get together to basically set up a nonprofit endeavor, in some states that's treated as an UNA as opposed to an unincorporated association, but that's not the case in every state. And if you don't make an affirmative filing in many states, if not all states under the UNA model law, you would be deemed to be an unincorporated association. And then there's also cooperatives, and cooperatives have been around for a long time. There's a lot of case law and kind of developed corporate law around cooperatives, but it's not exactly a tailor fit for the DAO structure either. And there's just lots of issues. Like, if you try to set up an LLC and call it a DAO, that can work for like a trading club. And there are many trading clubs that, are DAO trading clubs, set up as LLCs. But the issue is, if you want to transfer your shares, there's restrictions around that. There's corporate governance that just doesn't work for DAOs. And so really, if you do a full survey across the United States, you're not going to find a great fit, for a legal wrapper. And that's why most DAOs that have incorporated a legal wrapper do so in the Cayman Islands using a Cayman Foundation. Some have also used a Guernsey Trust model or a Panamanian Foundation. But really, these legal wrappers don't wrap the entire DAO. They wrap a portion. So you're still going to have an unincorporated association that's advising the board of this legal wrapper. And the legal wrapper board will say, okay, the DAO voted on X, Y, and Z. We're going to ratify that resolution, and then we direct the admin key holders of the multi-sig to go incorporate that on chain or do something off chain. So it really is almost it's not a full wrapper. It wraps part of it. It may shield liability, but you could still have aiding and abetting liability. And for aiding and abetting liability purposes, knowledge gets imputed across all of the general partners. And so if you have a DAO with a bunch of token holders and they're all general partners, even if just one of them had knowledge that they were violating law by advising the foundation to do something, all the general partners could be liable. The unincorporated association itself could be liable. And so there's not a great fit to really shield liability entirely, but there are a lot of things you can do to mitigate. And these foreign foundation legal wrappers are really the best way to do so that we have available today in terms of at least U.S. DAOs, or DAOs that are touching the United States law.
Ben, would you offer a perspective from you?
Yeah, so I fully agree with what Michael and Matthew were saying, and I have to say, like, also most of the DAOs I've been working with, it's always that these offshore structures like give a great flexibility, and then, as Michael said, they don't give full protection, but you could have with the DAO treasury the DAO treasury will identify all the token holders, and then you can create, like, through other legal documents some kind of legal safety for the token holders. But as Mike said, it's not the perfect fit that we see for these structures. And if we look at the EU, we also mostly see that there are associations are used for DAOs, which can be used, especially in Switzerland. They offer some possibilities, and there have been some DAO structures in that way. The downside is, however, that always when you have a lot of participants and you basically say the participation in that association is linked to the token, and the token is transferred, you would always need to change within the books of the DAO the partners of the association, right? So basically it always goes back to that, and also the Swiss Foundation is used a lot for DAOs, and always goes back to that foundation level, because basically if you look at corporate law, the big similarity between a DAO and the foundation structure is that in the foundation, the treasury or the money that gets put into the foundation is somehow autonomous. It gets away from the people putting the money in the foundation, and it can just be used for the purpose that has been given to the foundation. And most foundations, especially like in Swiss and EU corporate law, and so that's the big similarity and why our DAOs use that structure. But as also Michael explained, I think in the long run, the best is, and that's what I'm also going for in my PhD. I think we need some kind of legal structure which offers liability protection for all token holders. And I think it should be something like the Wyoming LLC, and I think the Wyoming, from the first idea, I was like pretty happy when I first read about it that we're going to that. But as Michael said, they didn't do anything like which can't be really used in real life. That's why most DAOs still use Delaware LLC over Wyoming LLC, right? Because it offers more flexibility and is easier to use. So I think we need some kind of LLC structure which really opens up for that decentralization, which would offer, I think, a liability protection. And I think the US should really move forward towards that, because what I just see is that where the CFTC and the SEC is going, just regulation by enforcement is creating such a legal uncertainty and really pushing the US back regarding crypto adoption and also regarding innovation, and that's what also caused at the end the FTX drama, right? You're pushing all these innovators that are in the US to go towards offshore structures, to go towards unregulated structures. But I think, and that's what I'm also planning for in Europe, that we create structure that, because most of the founders, entrepreneurs, they want some kind of legal clarity. There will always be the ones who can go for full decentralization and stay anonymous. And I think there's a good argument for that. And I think if they're full decentralized, they shouldn't be regulated, because there would be no point of enforcement. But on the other hand, I think we should, for the ones that really want to work within the legal framework, to give them an opportunity to really work within that boundaries and to create some legal certainty, on the one hand for everyone participating in the DAO, but also for the ones who really want to push decentralized governance in these protocols.
Great points. And that leads me to my next question. And do you think there is another reason behind the CFTC's filing legal charges against Ooki DAO as a way to set a precedent and actually move forward with other DAOs? And since they already set the initial precedent, it's fine to serve via chatbot or for Telegram group, Discord, whatever comes next, whether that is a way to start going after other DAOs as well, and maybe with some projects that are more easy that are easier to get. We had the issue of library token, and we also have the Ripple case ongoing. And apparently, I mean, the SEC and CFTs are their internal battle when it comes to crypto oversight. What can this mean for the future? We've been seeing some ridiculous cases. For example, the Kim Kardashian penalty of $1 million for promoting, despite the fact that she actually did put a disclaimer that it's a paid advertisement, and there were other cases as well. But it was a way to get into the news because a famous person was involved. What do you think? Is there agenda behind this for the DAOs and for regulation by enforcement in the future? Matthew, what do you think?
Yeah, it's a really good question. I think from what we've seen over the last I think 2 to 3 years, the understanding in the market of the idea of a DAO has kind of significantly evolved, because previously people thought of this DAO as kind of a thing, which is just automatic, which runs through automation or deterministically kind of run software. I think now the view in the market is actually that DAO is just a kind of a broad descriptive term for a novel type of kind of technology mediated social structure or organization of participants. And like the guys just said, those organizations can be structured in a whole load of different ways. And the most sophisticated and even unsophisticated DAOs now today use a whole load of different legal structuring tools. They use a wide variety of different legal entities. They probably use many legal entities within that kind of formalistic structure. So when you say Nike is a company, you don't mean Nike is just a single company, because everybody knows it has a whole load of trusts, IP holding entities. It's a huge corporate structure. And when you say X is a DAO, probably that you're just describing like the broad idea of it or the broad organizational structure. But when you get into there's probably a whole load of legal structuring behind that. I think, and that's fine when you have companies, partnerships, and all of these kind of very well trodden legal structures that we know. The thing that we will learn and the thing that we will iterate on over the next few years is how can those clear legal structures interact with open source code, right? And that's really the answer that we don't have, because open source code sits in the middle of those legal structures and token holders, and those are the answers, and developers, and those are kind of the answers that we don't really have, and we don't really have a normal way of we don't really have a historic, maybe I should say, way of dealing with that in the same way that we do for other companies and other associations of persons that are running things like sports clubs or organizations that organize your kind of local green and mow the grass and kind of thing like that. So I think that is the space where we'll see development, but I don't necessarily see this as being that precedent setting, because of the way in which DAOs can be structured in so many different ways, and that the term DAO isn't really a description of anything. So you can't really set that greater precedent when the term doesn't actually describe anything in particular.
Yeah, I think that's an important point, because it's kind of like a technology layer that you can use to support organizations. And so to the extent you have an organization that neatly fits into a limited liability company structure, for example, that can still be a DAO. But a lot of the DAOs out there, like I guess we call them really the protocol DAOs associated with DeFi protocols, for example, we're talking about Ooki, those types of organizations don't fit well into an LLC or into a corporation or into a co-op even. And so there's just not really a great legal technology to wrap the actual software technology.
Thank you. And Bian, what's your take on this? Whether it's setting a precedent or is just trying for them to understand a bit better the space and how differently they can enforce regulations?
Yeah, I mean, I fully agree with what Matthew and Michael said, that the term DAO is too broad to have a certain legal precedent. I just think for like the average user or participant of DAOs, it's just creating that he hears he could be personally liable, right? So if you look at it from a more legal perspective, of course, DAOs can be structured so differently, and it would be the same if you just say holding, right? Holding can be every kind of different legal structure, but I think it's creating some kind of precedent that we first see that fear that everyone had, that DAOs could be seen as a general partnership, that this gets established at one point. And of course, it will be not the precedent for every DAO case that we could see in the future, but it could always be brought up as an argument if the CFTC actually brings this through and the Ooki DAO will be qualified as a general partnership. So I see the precedent more from a social society or participating perspective more than from a legal perspective, because I think if you look at the DAO metrics, we already saw a big drop in participation and voting and everything since this came up. So I think it has a real world impact on the DAO ecosystem, although as Matthew and Michael explained, the legal impact could be quite smaller than expected, but it already had this kind of big social impact on the whole ecosystem.
I think that's a fair point, that to the extent that it is considered correct to treat token holders of a open source DeFi protocol as either members of an unincorporated association or partners in a general partnership, and therefore treat them as having unlimited liability of the actions, or not even actions of the protocol, of the kind of the consequences of the protocol as built out by others. I think that would potentially have the effect that you described, Bian. So I think that is a fair point.
Yeah, I mean, DAOs are, I would agree and disagree that DAOs are a broad term. I think DAOs are by nature and by default broad, but not by definition what they are and what they can do, rather by the fact that they are decentralized and they can be just about anything. And when it comes to these things, it's also important to understand what the project actually is trying to achieve, and what is the mission, what is the vision behind the project, how the token is used, and generally understand the community. The problem is that each and every DAO is very specific, and that you need to have a very individual approach to each and every project in order to understand it and apply on certain regulations, or even craft regulations that could apply to DAO as well. When it comes to traditional world businesses, more or less, they all fit in a very similar to same box, and it makes them a lot easier to regulate, especially since they're as well very jurisdiction specific. However, the problem is that the basic education is not there, and putting the token holders who vote on a certain project matters, and potentially being liable for some of the consequences, even though the certain vote did not have any compliance implications. For example, what if they voted on brand colors, or what logo to choose, or do we like this interface, or do we want to change it? I mean, those are, compared to compliance issues, those are very insignificant decisions and vote that these holders are voting on. And the problem is that that is not taken into account, and it can definitely hinder the DAO governance and development of it. And we know that the current DAO governance has so many challenges, and it really needs to evolve a lot within the industry and within the community, let alone for the regulators to be able to understand it. And regarding the open source code, I mean, from recent past, we did have that unfortunate event where the regulators do not really understand the very basic definition of an open source code to tornado cash event, and with that unfortunate developer. And another issue that I believe there is that they're not even trying to understand, and they see the whole industry as a Ponzi scheme, as a way to get rich quickly overnight and get out and scam or whoever, whenever. and many of these regulators are quite of anti-crypto and very vocal about it. And the question is whether people who are so much against something can even bring the regulations that are good for the environment, and whether they can rationally even apply the existing regulations that are not applicable to the industry, and what effect that can have on the project and the development. And recently I've been reading a lot that people are changing their GitHub names, right? So they do not want to post anymore from their personal accounts. They are changing their Twitter names, or even canceling them just to avoid any type of association. And I'm also curious to see what's going to happen with N's domains and whether we will see a drop there or a huge change. And it doesn't make anyone feel safe in the space. And we have already so many existing issues when it comes to scammers, rug pulls, hacks, the lack of regulatory clarity in general. And this just adds additional pressure of everyone involved. And one more question before we close. What would be the other option that this could have been handled? I heard some of the opinions that instead of going the token holders, the regulators should have gone after the founders, because they're the ones that are actually known to the public, and they made the transition from the BZX to Ooki DAO. As Matthew also pointed out, the question is whether these token holders were even involved in the development of the protocol, and how decentralized that LLC actually before was, and whether there was the ability of the community to vote on the exchanges. Michael? Would you like to?
Yeah, I think one important point there. So the CFTC is characterizing this as an unincorporated association, as a general partnership. General partners aren't necessarily liable for everything that the general partnership has done in the past. Okay, so there are going to be token holders that voted on things and were involved, but they weren't involved. For example, in X violation. The issue here is that you have a long track record of this. Let's call it what would be required to be registered as an exchange, and so the CFTC doesn't really have to parse anything unless there are individual token holders that had tokens at one point and then noisily exited by selling those tokens or burning the tokens or whatever. So the CFTC had a relatively easy case to make that this is a general partnership under the state's, corporation laws, and that individuals holding the tokens were, whether they voted to do anything illegal or not, had been voting and kind of been involved in this partnership. Whether it's something engaged in for profit, that's an open question. I mean, the CFTC would have to prove that there's, each of the elements of the general partnership definition are met under that state law. The CFTC did bring a case against the founders. So that case got settled. So there's enforcement action. They settled that. I don't recall the exact fine number, but they paid a penalty. That's handled. The issue is this transition to the DAO, where there's a bunch of chatter and a bunch cited in the complaint about these founders passing along control and governance over the protocol to this DAO, so that they wouldn't have to be in a position where they'd be liable for operating an exchange.
Yeah, I mean, the penalty was, I think, like $250K for that, but the issue, I think the issue still remains the fact that they just found a way to transfer the liabilities from themselves to something else, to a DAO, and to the whole community. Shouldn't really clear them from everything and go after the token holders that are there and probably didn't have much say even, and probably don't have enough education to understand what the potential implications of that act could be down the road. And I'm not going negative against the founders, but the fact is that this act was quite irresponsible from having a legal entity that could actually protect the project. They went to a non-legal situation and put everything on the holders, and now random people in Telegram chats are disappearing, and the DAO governance in the communities are in panic precisely from that act, from being, and being quite honest about it on the social, now we don't have to be compliant. Like, we can avoid CFTC and SEC potential, whatever they could bring on us, because we went DAO, because it really stains DAOs. And unfortunately, it confirms that terrible narrative that people who are in crypto, who are in DAOs, who are in blockchain in general, are just outlaws finding the way to break the law, being uncompliant, and commit frauds. And for that reason, it casts like a really bad shadow and tags the founders as quite irresponsible to their community, first and foremost, and the most, and then the project and everything that was invested.
Yeah, and I think it's a fair characterization. I think the issue, though, is that as a black letter law matter, when this, let's call it, an illegal exchange, when the governance and control over that was passed to the DAO in an attempt to evade regulation, there was arguably an unincorporated association that was controlling an exchange that was required to be registered with the CFTC. And I think the idea of transferring that responsibility to the DAO, whether the CFTC could go seek a judgment against every general partner just on the basis that they were a governance token holder who voted, that remains to be seen. But the CFTC is not attempting to do that, and so I think there would be a much higher bar to try and bring those types of claims, and that's probably why the CFTC is not doing so here. But seeking this judgment against the DAO treasury, whether that's a good thing, like from a policy perspective or not, I think the CFTC has some arguments that it's able to do that on the basis that this is a person, whether you want to call it an UNA or an unincorporated association or any other type of organization. The CFTC has pretty broad authority to bring an action against any person that's operating an exchange or offering margin leverage or financing.
Thank you. And what do you think, Bian?
Yeah, I mean, there's a point, but I also think the position of the CFTC is also like attackable really from a legal perspective, because I think that the CFTC basically divides the token holders into the ones, I think they said, voted those tokens to govern, and it's, from my perspective, they don't make it legally clear, like it's some kind of like arbitrary distinction between like different token holders, because what's with the ones who disposed the tokens or who didn't use them or who delegate. So I think from that perspective, there's also a good point for token holders who go against this to fight against the arguments of the CFTC, because I think in some cases they just took a little bit of the easy road and claimed, all right, everyone who somehow voted, but they didn't really define it and who falls under it. So I think there are good points, and I think in the amicus statements, some of these were really good and targeted good points in the argumentation of the CFTC. And I think, of course, it created such a such a big recall in the legal community and the crypto community. And I think that's important, because here we really see and I just see as an attorney working outside of the US, that there's this competition going between the SEC and the CFTC, where the SEC says, and that was also in the case against this against the ICO proclamation of Ian Bellino, where they said there are nodes running on Ethereum nodes running in the US, so that makes everything on Ethereum running under the SEC regulation. So this competition between the CFTC and the SEC, where they both try to get as much hold of crypto under their regulation as possible, really hurts the US in the long run, because it really scares away any innovation in the crypto space from the US. So I think if this case could be could be defended well, and there's not a judgment against it, would create a good, like, beneficial outcome. And I think at the end, also for the US, like from a business perspective, I think it's not good to scare all that innovation that basically is happening in the US. There's a lot of founders from the US. There's a lot of like crypto adoption in the US. I think that should really be focused. And I think we really need to focus back again on the real like idea of crypto, which was decentralization and trustless like financial structures for people who couldn't be part of the financial system before, because now going everyone after crypto with the FTX case and other cases, these were just like unregulated shadow banks, which basically were going against the idea of crypto, right? So I think we will see a shift towards more like real decentralization, and I think that's important. And I think the US should not try to fight that, but more embrace it to not fully lose that, because we already see the MiCA regulation that we now getting in the EU got a lot of like positive from US lawyers. There's a lot of positive appreciation for it because it creates some legal clarity for centralized crypto structures, and it doesn't tackle DeFi at the moment at all. So, and I talk regularly to EU regulators. Some are even pledging to fully leave out DeFi. I think we will see if that's going to happen, but there's a good argument for really decentralized structure to fully leave them out of the regulation, because there's no point of regulating, right? And these suggestions that were made to regulate the interfaces of the DeFi protocols, I think that's not really the solution, and it kills the innovation that we saw here. So, and I think there's like, people either have to trust centralized exchanges and trust what they are saying, or they can just trust the code, which can be audited from different companies. And for example, if someone wants to invest heavily into a DeFi protocol, he can lay out, I don't know, 20, 30, 50,000 to a big, good auditor and let it audit if he can't audit by himself, right? So I think there's some case for DeFi to stay out of regulation, and I'm really pledging for that. And I hope we will see crypto more evolving towards that, and not the regulation killing it before we can really evolve towards that.
Yeah, it's interesting to see when you mentioned the centralized exchanges, since many are blaming the FTX event on crypto. Well, many are actually failing to understand that this still falls under CeFi and is regulated in CeFi, not on this side. And the interesting is that exactly the SEC and others in the state failed, where they actually could implement and execute the regulations they are now preaching to have in crypto, but in a very, very wrong way. And Matthew, what do you think? How will this turn out?
Yeah, so I think your original question, or your original last question was, how might this have been done differently? And I think...
Yeah, in terms of the founders and whether...
Yeah, so if you look at I think the really interesting and useful kind of amicus briefs that were filed, I think there was a Lex Punk one, there was a Paradigm one, and a DeFi education one. They take really specific points and procedural points and descriptive points, and they take issue with some of the ways in which the CFTC presented those. I don't have any kind of like US background on exactly how you would run a case like this, so I don't really want to comment, but I think that it is useful to read Commissioner Summer Messenger's dissenting opinion, because in that opinion she does describe an alternative method of getting to kind of the similar result, or to the same result that may have been kind of less objectionable to the community, and may not have needed to rely on the kind of the principles that may be put in place that we've discussed today. So I think that's really important to remember, and it's not necessarily that people don't agree that something bad might have happened here. Probably some people do disagree on that, but there are different ways of approaching the same problem, and I think that was really clearly enunciated by Commissioner Messenger. So that would be my kind of thought on that. I can't go into like the procedural details because I don't know them and I get them wrong, but I think there are different ways of skinning cats, right? And yeah, I think that's just worthwhile bearing in mind when we're in this new area of kind of open source DeFi smart contract systems.
I mean, it's great to know that there are actually CFTC commissioners and on SEC that they're actually looking at this from a different perspective. Like we had the same with the senator and the SEC commissioner who said, "Well, it's not crypto; it's actually the failure of regulators." But then what happened? They actually got a large backlash from the other SEC commissioners, and the same happened with the CFTC when she posted that. Listen, but it does really matter to know that there to see different types of opinion from the regulators coming as well. So that does definitely give a bit of hope on how some of the things will be handled and regulated in the future. I would like to thank you everyone for coming on today and being with me despite some of the tech issues I had. It was wonderful talking to you, and I'm looking forward to seeing you in some of the next episodes.